and good evening everybody. Thank you for attending the BBA lecture series. This is the second lecture that we are having in the lecture series for the year 24-25, and thank you for attending this lecture in such large numbers. Like we did on Wednesday, due to the overwhelming response that we've got, we have also opened the Nextdoor library, and we are streaming this lecture live in the Nextdoor library so that people who otherwise could not sit over here are sitting in the Nextdoor library and getting the benefit of listening to this lecture. The topic for today's lecture is the BNSS and the BSA. So without any much further ado, may I request Shri Nitin Thakkar, our President, to address the audience.
Good evening, friends. First of all, a warm welcome to Justice Dangre and Justice Deshpande for having come today. We are thankful to Justice Dangre for having agreed to deliver this lecture, and one may feel that on original side counsel why they need this lecture, but for each and every student of law it is very important to know and understand even basic things of this branch of law. Though we may not practice it, someday we may have to go for some matter and it may be useful. So thank you very much, Judge, for having agreed to come, and I will not take any much more time. May I request Sneha to welcome Justice Dangre and present her with our token of our love and appreciation. May I request Justice Dangre?
A very good evening, and I'm rather glad to know that on a Friday late evening at 5 p.m. so many students of law are still interested in getting knowledge. And the surprising factor is this: I'm being told that as far as when I came to know that this is a lecture for the original side lawyers, but I can see so many faces which rather appear on the criminal side also, and I'm quite conscious of the subtle distinction between the original side and the appellate side, not the bar, even at the benches also. But fortunately or unfortunately, I think I'm a common factor who has worked on criminal side and civil side also. And the reason being this, that in Nagpur we don't have any demarcation like this. Nagpur is a small place. So Nagpur, wherever, whichever type of matter you get, you just want to jump on it. So whether it's the office of commissioner, whether it's collector, and there is no distinction between civil and criminal, and therefore we were fortunate in a sense that jack of all and master of none. So we knew everything little, but that has thrived us. Now it's very interesting that since the new laws, we were in fact, from 2020, a committee was appointed to have a study and to have an overview of the existing laws, 3 laws, IPC, Evidence Act and the CRPC. The research work started going on 2020, inputs were called from various agencies, various experts in the field, and somewhere in August, when the bill was introduced, a lot of debate was ongoing as to what would be the repercussions, whether we really there is a real need of overhauling the whole system. What was wrong with the old system, which was IPC was thrived, it's 1860 framed by Macaulay, so is what otherwise also was doing well. Procedurally also we felt that we were strong. It was not that the procedure was lacking somewhere. Evidence Act, as far as the basic principles of evidence, whether it's a civil suit or whether it's a criminal trial, the principles will prevail. So after a lot of brainstorming, or a lot of heated debates and discussions, ultimately, on 1st of July 2024, the laws came into force. I'm not going into the aspect whether the laws are good or bad, because that was a discussion which was open to us once upon a time, but now with the laws having come into force, this is a discussion which is not open, and why should we focus on it? If we look at, once we have studied, once we have cursorily, a person who has gone through these three statutes would definitely be satisfied that the laws are going to advance the criminal justice system of administration of justice, definitely. The reason being, firstly, we see that the earlier laws, we are not talking about the procedural laws, but mostly if you see the IPC, you will find that most of the offences were colonial in nature. More focus on what you can say punishment rather than reformation, and that was the main emphasis in a colonial era, so it's good. Adding some offences, you will find that largely the offences have remained the same, barring addition, which was the need of the day, like you have an offence of mob lynching. That was the need of the day, because there was no specific provision dealing with it. You could not have put it under 304A, neither under 302 strictly. So a separate category is created. Now rash and negligent driving, no other option. Hit and run, it was always 304A. What was the punishment? Very minimum punishment. So it was necessary that we have a separate section on this hit and run, though there is no intention but accident had taken place. So of course you have, a lecture was already there on Wednesday on the IPC, so I need not delve into it. As far as the procedural law is concerned, the criminal procedure is concerned, the most important facet which was lacking, or rather we needed it to be updated with the current, because the laws, the 1973 Code of Criminal Procedure was interpreted, many of its provisions were interpreted from time to time by the High Courts and the Supreme Court. Like for example, if we take an example of arrest of a person. Now, we all know that though the police has a right to arrest a person, or police may want to arrest a person, an investigating officer, it is not mandatory. It's not that as soon as a cognizable offence is registered, a person need not be arrested. Though he has a discretion, but the question always came, how does the officer exercise his discretion? So it used to be at many a times the officer always felt that no, it's my right. So a time came that the Supreme Court said that for offences below 7 years, why are you arresting? So Arnesh Kumar was the first decision. Time and again the Supreme Court said that below 3 years, why don't you follow the procedure that is prescribed? Already there was a wonderful provision in the earlier code saying that below 7 years you give a notice to the accused to come and appear before him. You inquire with him, you investigate with him, and if you feel that he is not cooperating or his arrest is necessary for discovery of something, then you arrest him. You record the reasons for effecting his arrest. But instead, it was always considered to be a right from Jacob Matthew, when the Supreme Court said that this is not to be done. How can you really arrest someone? Now since that time, but irrespective of the fact that the law was let down, unless and until it is on the statute book, the police officers kept on arresting. Accused used to come before the court laying down the same law that why is it required in below 7 years don't. Then came until. So many series of decisions repeatedly. Now there was a need that you should have this provision in the statute itself, so that it becomes escapable. Everybody will follow it, it's not the discretion. So this was one important provision which we can say. Now what was thought was, and since we are overhauling the whole criminal system, we'll have all these interpretations of various provisions introduced into the statute itself. Another important aspect was the introduction of electronic evidence. With the advent of electronic media, now everything is, we all know now, it's very easy. Now we'll tell you an example that if a Panchanama is to record it, most of you are not familiar, there's a Panchanama when the offence takes place. On the site when the investigating officer goes for the first time, it's very necessary for him to notice everything that is there, because that is the basis on which the trial judge, the High Court, and probably up to the Supreme Court, the guilt of the accused or his innocence is going to be proved. Now it's very necessary that you see what is there. There is one door is here, another window is there, there was a fan, there was some things are lying here, some clothes were found there, whether there was any robbery. Now, for this purpose, the Panchanama is a very important document because it gives you an insight for a judge to see, because a trial judge also, he will depend upon he will also rely upon the Panchanama as to what was the situation, from what place he could have entered, from what, whether there was an exit, whether the windows are open, whether there is something from outside where he could have gained an entry. So unless and until it is appropriately given, because what's the whole difficulty of the session judges and most of the High Court judges when the appeals come, because we get only the recorded proceedings. Now we have to rely upon, you can't go into anything new. The most important feature of a criminal trial is this: once a trial starts and whatever matter comes before the session judge or a trial judge, that continues to hold the field till the matter goes to the Supreme Court. You cannot add, you cannot delete. Now, what was the position of the body? Now, when an inquest Panchanama is prepared, inquest is when the dead body is examined, I mean outwardly. Postmortem is different than the inquest Panchanama. Now, even that inquest Panchanama comes, but just a minute. Now, the inquest Panchanama gives you the description in which the body was found. Now, so many things are important, whether just to find out what is the time of death. So it has to be seen whether the rigor mortis has set in, how is the position of the body. Now, unless and until you have somebody who is really an expert or who has really noted the position of the body with all those niceties being described, then it becomes very difficult. You really don't know, then you can't argue. Once the body goes, once the body is disposed of, you are not going to get to see the body. It's only after the postmortem the doctor will give its report in a different perspective, because he would be examining the body of the corpse with an intention to find out what was the cause of death, what was the internal injuries. You will never get this position of what was the position of the body when it was found. So these are very important documents, and you will find that when a defense lawyer argues in favor of his client, he will focus on all these minute things. For a police officer, it's his normal duty. He will miss out things, but for him it's as simple. He'll say, all right, doesn't matter. I wrote ek room hoti, they have their typical, because who writes a Panchanama, it's an officer at the rank of constable or at the most an head constable. It's never written by an investigating officer, though the investigator signs, it's all a well-known fact to us. So it's very necessary that we have something which is recorded. Now you see, now it's possible. Now what do the police officers also do? You will find on the roads Chalan. Now Chalan, the police officer who stops your car, will click a photo. It's as simple it is now. Then there was a thought was given that if we have so much of technology, now why don't we have recording of all these things? So now the most important facet in the Evidence Act as well as the Code of Criminal Procedure is recording of evidence by electronic modes. Now this required an overhauling, because if you see Evidence Act, there are not much changes, but the changes are what is the primary evidence and how, because lot of time we were struggling because we were dealing it with 65B was a provision which was added. The question was, how do you prove this document? Electronic document. Electronic document is defined now in the Evidence Act. How do we prove? So right from, I think, now after Arjun Khotpal, the decision is settled, but otherwise from Rafiq and earlier to that Navjot Singh Sidhu, we were still struggling. Ultimately now the Supreme Court said that if you bring the device as it is before the court, then it can be read as a primary evidence. But if you are transferring some data from this device, that is from CCTV footage, it comes into a hard disk and then into a pen drive, because it is stored in a hard disk. Then you take it out from there, you have a pen drive or you have a CD, you place it before the court, play it before the court, then this will require a 65B certificate. So a lot of time we were struggling. So you see, when you have to appreciate and bring an evidence of such type, because the most important thing is there should be no scope of tampering in this evidence. That's the most insignificant aspect. So have its credibility maintained intact, you had to introduce such provisions so that it will make it foolproof. So that is how it was decided that we should have a better system to see to it that the whole modern technology is also gets introduced into the procedural step. So we have it is introduced in the Evidence Act as well as the CRPC. Now, this Bharatiya Sakshya Adhiniyam largely remains the same. I'll just briefly come to it later on. But the most significant change is the Bharatiya Nagarik Suraksha Samhita. Now, this is a bill which has replaced the Criminal Procedure Code. Now, at the end, the last section of this act, you will find a saving clause. So, it says that all appeals, all proceedings, all inquiries, all trials and all investigations also, which are ongoing, shall continue to be governed by the old code, that is 1973. But any notifications, gazette notifications which have been issued, like conferring some powers on a court, special courts, that will be deemed to have been issued under the new act, so that you maintain the continuity. Now, this is going to be susceptible for, fortunately there are not many criminal lawyers who are sitting here, but this will be a matter of scope for interpretation. If you read it carefully, there is a little catch in it. Of course, a good criminal lawyer will be able to say how. Now, otherwise what would have happened, a procedural law can have retrospective effect, though a substantive law may not. A punishment according to Article 20, you cannot be punished for an offence which was not an offence ex post facto laws. But as far as procedural is concerned, the procedural can be made retrospective effect, but now the legislature has taken care, and in the last section of CRPC it has provided a saving clause. Now, the most important highlight of the Criminal Procedure Code, I'll just give it in points and then I'll go to one by one. It is outdated colonial era legislation that has been done away with. Second is the resolution, relevance and evolution of society, as I have told you, the modern technologies which are used. And we have to always keep in mind that no doubt the criminals are becoming smart, so even the system has to become smarter. Because initially we used to only see it in English movies, that some attack takes place only working on the computer. We have seen in our young days, but now this is actually possible. I remember, I don't know what's the name of the movie, but there was a movie when the medicine, the medicine which was given to the patient, because it was all kept in a system. So they just managed and manipulated the, I don't remember, it's a very old movie, and the medicine dose was increased. The nurse was not aware because she used to only see the computer and find out this is the dose given. She never realized that the doctor has not increased it. So the system was hacked, the dose was increased, and that proved to be lethal. So this was what we used to see in the movie, but this is now possible. From our laptops we get phone calls also. So this is how its hacking take place. So to deal with this, it was thought better that we have a system to deal with this complacent scenario. Now, most important was enhancing the efficiency of criminal justice system. Now, when these laws were debated, a lot of question arose that is it, by introduction of this code of criminal procedure, are the delays in the trial going to be reduced? Are the appeals going to be heard in shorter period of time? Probably the answer is no. But by imposing timelines on carrying out the investigation, charge sheet to be furnished, appeals to be conducted and judgments to be delivered, that is at least an attempt has been made. But we all know with the pendency of the criminal cases to how far extent practically we would be succeeding. But the aim is to see to it that as far as at various stages there are timelines fixed which may rather enhance the ability of the system to cope up with the justice delivery system as far as criminals are concerned. Now, the important features, again another, as I have told you, promotion of technology, mandatory video recording. This system has been made another aspect of this, that the system should be such that it should be friendly to the victim or the complainant. Because all the while we have only expounding upon the rights of an accused. He has a right under Article 21, at every stage he should be given hearing. But now it was thought the other way around, that it should be victim friendly also. So a provision is introduced that as soon as whenever a complaint is registered, within period of 90 days, the victim or the complainant should be informed what is the progress of this investigation. So that otherwise, the complainant is the most neglected element. You are only talking about the accused, his rights, his demand, at what stage. But the complainant do not know only at the end stage. Now at least fortunately we have the provisions which provide some compensation to the victim. The definition of victim had already been expanded in the earlier code, but now here the right is conferred on the victim herself, and now it is mandatory to inform, keep the victim informed within 90 days as to what has happened to the investigation. Now, another important provision which is introduced in form of section 360 is that withdrawal of prosecution. Now, withdrawal of prosecution is not, it's a very complicated affair. Earlier it was section 320. Now it said that it should be not the prosecution, but it should be a public prosecutor who was given the power to make an application for withdrawal of prosecution. Time and again the Supreme Court interpreted that he should apply his mind. The public prosecutor, he is not a mouthpiece of the government. He is not a mouthpiece of the prosecution, and he will not say that the government wants to withdraw, because there may be a hidden agenda, there may be so many reasons why the government want to withdraw the prosecution. Now there is a provision that the victim shall also be given a hearing at this stage. So this is very important facet, that when a prosecution is sought to be withdrawn for whatsoever reason, the victim's say will be obtained. A very significant feature. Then magistrates are now empowered to take cognizance of offences based on electronic records such as email, SMS, WhatsApp. Mercy petitions and appeals, they are to be decided. If in mercy petitions, in death sentences, cases must be filed within 30 days to the governor and 60 days to the president. We have come across a case in Maharashtra only, when the death confirmation for 15 years, the death sentence was imposed, but it was pending before the president, went back and forth, and ultimately that was required to be commuted. Only because of the reason that there was a hope of life in this prisoner, who, if he would have hanged before 15 years, would not have this expectation, so it was required to be commuted. Now these are some of the salient features. Now I think we'll come to the provisions one by one, so that we get an idea of these entire system, the scheme itself. Now if we turn to the new criminal, this is, I gave you the overall, where are largely the changes. Now some changes are very significant, but we'll deal with it when we come actually to the provisions. Now audio, video, electronic media, video, electronic means has been defined, because there was no earlier definition, it was something new. I need not go to the definition. I must make it clear that I am not going provision, I am just giving you a broad overview, so that when you read the statute, you follow what was the original position and what is the change in the statute. Then we all talk about bail, but bail was never defined. Bail, it was 437 to 439, but there was no definition of bail in the earlier provision. Nowhere the bail was defined. Now bail is defined for the first time, means a release of a person accused of or suspected of commission of offence from the custody of law upon such conditions which are imposed by the officer or the court on execution of bail bond or his personal bond. Bail bond is defined, bond is then defined. Electronic communications is defined specifically in 2I. Now important feature is this, as far as investigation, the definition remains the same, that is a process of collection of evidence conducted by a police officer or any person other than magistrate who is authorized by the magistrate. That is, collection of evidence is what you call as investigation. But here, because you have different mechanism now, under PMLA also if you go, there are different mechanism. Now there is an explanation here, it is added, that where any of the provisions of a special act are inconsistent with the provisions of Sanhita, then the provisions of the special act will prevail. So whatever mechanism of collecting evidence for the purposes of investigation, if there are special mechanism provided in the special act, then that will prevail over the Samhita. Now there is not much change in the first portion. Now one significant change as far as the composition of courts are concerned. Now we had the judicial magistrate first class, we also had the additional judges and metropolitan magistrates. Now as per the new Sanhita now, the post of the magistrates of third class, magistrate, metropolitan magistrate and assistant session judges are abolished. So now you will have only 4 kinds of judges: judicial magistrates of first class, second class, which include the chief judicial magistrate, and the session judge, which includes the additional session judge. Now there will be no metropolitan magistrate. Now, of course, this will have to be dealt with because the High Court will have to modify because the designations are contemplated. So, probably under the saving clause, subclause 2, which says that all those notifications which will prevail, the nomenclature shall be changed. There will be some changes which would be required to made with the competency, because now what happens is this, that whenever a person is appointed initially as a district judge, he is appointed as an assistant judge. He is given a ranking of assistant judge, and only after 25 cases or judgments he delivers, then he takes the seats of as an additional judge. But now we'll see, the High Court will have to deal how to come across with this. Now, the powers of the magistrate to impose the penalty is also increased. Now it was initially 10,000, now it is increased to 50,000. So that is the pecuniary power to deal with in the limit of imposing fine. So now it is from 10,000 to 50,000, and initially where there was 5,000, now he can impose a fine up to 10,000. Now, another salient feature of this statute is constitution of the Comprehensive Directorate of Prosecution. The purpose is to fix accountability. This is introduced by in section 20 of the Act. Now, earlier, of course, there was a Directorate of Prosecution, but we could hardly see the Director of Prosecution playing any role. Now, here the accountability is fixed by creating two cadres, those who are dealing with sentences more than 10 years and those who will be dealing with sentences below 10 years. Now, every time whenever an appeal is to be filed, an opinion shall be sought, a reference shall be made, because many times we come across cases where the appeals against acquittal, the state comes in appeal. Now we find that it is so frivolous. So time and again we have judgments where the courts have frowned upon this approach that any appeal you bring before us. So has anybody tested, has anybody applied its mind? And I personally, working as a prosecutor, I know it. We had so many times received the wrath of the court when the court said, what type of appeal, what is the merit? And I said, no, my lord, that was because the government asked us to file the appeal. Who asked you to file the appeal? My lord, the law and judiciary asked. And they used to ask, we have all faced this. Bring the recording of the law and judiciary. And when the recording comes, you know that some MLA or somebody has went and he said that, oh, please file this appeal. So this appeal has to be filed. So no matter whatever we do, the appeal had to be filed. But now to cut off this procedure, or in some cases, there is also a possibility that an acquittal, it is an acquittal which ought not to have sustained, but still no appeal is filed. So therefore, for this, now you have a Directorate of Prosecution. The officers will be appointed, who will be at the rank of the Assistant Director and the Additional Director of Prosecution, who will be advising the entire prosecution wing. Now this is going to be a very significant and important aspect in the system. Then we come to another important features are you have the Special Executive Magistrates. There is no Director of Prosecution was 25. Court, as far as the powers of the court are concerned, we don't find much of the substantial changes. Now we'll come to the chapter of arrest. Now arrest is a very significant aspect as to when a suspect, because the journey of the criminal process is from a suspect to an accused and accused to a convict. So between this suspect to an accused, he has certain rights. Time and again we know that Article 21 along with Article 22, it has conferred certain rights. Now you must all be aware that a recent decision of the Supreme Court in Pankaj Bansal, which is followed by a subsequent decision, it says that because earlier it was only in the preventive detention laws, because preventive detention in a way is a short-circuited process for detaining a person. It's without a trial. Just because a subjective satisfaction is expressed by a particular officer on whom the power is conferred under the detention law, by exercising his subjective satisfaction, the person gets detained. Therefore, in that statute, it's very relevant right from Article 22, 5 and forward that the grounds of detention should be furnished forthwith. Because otherwise he has no reason to know as to why I am being detained. So the first threshold, at his detention, the grounds of arrest, and it is on these grounds of detention he can make a representation to the detaining authority. After the order is approved by the state government within period of 12 days, then he can make a representation to the advisory board, because it's not something that a person can be just detained. Because detention order, most of the laws, you know that COFEPOSA, MISA was the earlier law, now we have the MPDA. A person can be detained in Maharashtra being a dangerous person, a bootlegger, and so on, slumlord. Now, if the detention order is for 1 year, this is without trial. So he should know what is the basis on which I am detained. Under what is the consideration by the detaining authority, what went into his mind in coming to a conclusion that I deserve to be detained. Therefore, this is very imperative that the grounds of detention were to be communicated. Now, we all know the case of D.K. Basu versus State of West Bengal. In consonance with right of Article 21, it said that whenever an accused is to be arrested, some of his friend, relative should be informed of his arrest, so that it do not happen that he is confined, he is taken into custody and his family members do not know. And it's not unusual. I mean, the police machinery sometimes from some place will pick up a guy, just put him down, his family doesn't know where he has gone. Or sometimes now at least we ultimately, because of various directives, specifically in D.K. Basu as well as the Supreme Court frowning upon this type of approach, there are less number of custody deaths. Otherwise, once was a time 2 decades back, we had so many cases of custody death, and the problem was this, it was not even shown that he was taken in custody. Now, therefore, to do away, of course, the Supreme Court by issuing guidelines, D.K. Basu guidelines, were intended for this purpose, that whenever anybody is arrested, somebody from his family should be made aware. Now, in Pankaj Mittal, Supreme Court has again came back to the same square, and it said that it is not, because the question is this grounds of, now you have a pro forma. You have an arrest panchanama or arrest memorandum. Now, arrest memorandum, if you find, by those who work on the criminal side, they must be knowing that it has got some 22 to 23 columns. But none of the column is filled up, except that first column, name, time, that's it, and then you don't know what is written, and most of the columns are vacant, blank. Now, in fact, there are columns which says that Karane. Karane is different than, the Karane is reasons, not grounds. Karane, then they ascribe something the poor family don't know. But on the first paragraph of the pro forma, Konala Maiti Dili, it's in Marathi, Maiti Dilaleche now. Now you just write down something. But now the Supreme Court said that even in case of a normal arrest, of course Pankaj Bansal came out of PMLA, where there is a twin condition imposed. But then the Supreme Court expanded it by saying that now it will be imperative in every case that the grounds of his arrest are informed. Because otherwise what happens, the person do not know what are the grounds on which I am arrested, and even the column which I told you, the form which was there, Karane, so is to say orally communicate kele. Now who knows orally? Everybody has his own version. Police officers say karavle hote. So many cases, this was always the argument, tala sangitlo hoto. But either that person who is illiterate, who don't understand, or it is never told to him. So now the Supreme Court has ultimately said that it should be communicated in writing, even in a normal arrest. So, but unfortunately, this is a decision which has come just now, but this is not a part of the act as such. Arrest, however, section 43, initially it was 41, the section remains the same. But here there is one more important aspect is, since the police officer always assumes that it is my right to arrest in every offence whatsoever trivial it may be. So there is a provision introduced in 43 subsection 3. Now it says that, this is a provision as regards handcuffing that I'll come to later on. Now for an offence which is below 3 years, or where an accused is infirm or a child, then with the permission of the Deputy Superintendent of Police, the power of arrest should be exercised. So that any infirm person, old person, young child, or where the offence is below 3 years. So that this will minimize the arrest and putting people in bar, and that all this, some burden will be reduced. Now one very peculiar provision, which again will be a matter of interpretation and how it is to be looked upon. In D.K. Basu, the Supreme Court and subsequent decision, handcuffing was specifically, Supreme Court said that no handcuffing. Because it was said that this was violated, it was held to be violative of Article 21. Now 43(3), the provision is again introduced. Now there is of course it is safeguarded by certain categories, setting out that only in this category of persons handcuffing can be allowed. Now this provision says that a police officer may, keeping in view the nature and gravity of the offence, use handcuff while making arrest of a person or while producing a search person before the court who is a habitual or repeat offender or who escaped from custody or who has committed offence of organized crime, terrorist act, drug related crime, illegal possession of arms and ammunitions, murder, rape, acid assault, counterfeiting of coins, currency notes, human trafficking, sexual offences or offences against the state. So in fact, largely everything is covered. Now we don't know what remains out of this because Arms Act, possession of arms under the Arms Act also, so illegal possession of arms also handcuffing. So this is now, of course this provision will be again have to be tested. Once again the guidelines in DK Basu, but legislature intended that handcuffing should be allowed in this type of offences. Now when the accused is arrested, there is sometimes much needed that he should be medically examined for 2-3 reasons. For 2 reasons basically. Firstly, to find out, like in cases of rape, you will find that either there was a resistance or in case of dacoity, that some resistance or something. In cases of rape especially, you will find that whether there was some resistance by the prosecutress. Now at that time, medical examination, at least external, we are not talking about the medical examination of his private parts, but externally also, to see whether he had sustained any injury or a scuffle had taken place and he had sustained any injury, then whether his presence could be proved, because he says that scuffle took place and he had injury, it means that his presence, he was a part of that act. So at times it becomes very necessary for the accused also to be medical examined, but that was the most ignored aspect of the whole case, because some or the other time after putting him in jail, it's also necessary for the reason that if at the time of arrest, if subsequently in the custody, if he is given any 3rd degree treatment by the police. Normally the case is this, that you will find in most of the, when they are in custody deaths cases, you will find that the people gathered there, he was caught and people only thrashed him. Then he was put in custody and therefore he died. So at that time when he is arrested, it is very necessary that he is medical examined so that everybody is on the safe side. Even the police personnel are on the safe side so that they can show that these are all the injuries. This was his condition at the time of his arrest. And it's not that the report, it says that the report should be immediately forwarded to the investigating officer. So not with delay. This is one significant provision. Now, this is as regards the medical examination. Now, forms of summons, service of summons to an accused was the most troubled aspect, but even now it would remain the trouble aspect, because now it says that every summons shall be served by a police officer or the state, any authority where the state government may make rules. Only one safeguard is this, that the police station or registrar in the court shall maintain a register to enter the address, email, phone number and other details as the state government may by rules provide. Of course, this rule state government will have to formulate the rules now, so that, but it's not unknown that at the time of one who is released on bail, nobody is available for trial. Even if convicted or released on bail, not available when the appeal is being heard. So let's see how it works, but that's going to be a trouble area still. Now, service of persons, now it has been made gender neutral. If you remember, the service of summons on the male adult member of the family was the earlier provision. Now the word male has been removed, it says an adult member of the family, it would be considered to be a valid service. Now one important aspect is the 82.2, little bit of introduction of DK Basu but not Pankaj Bansal. On the arrest of any person, the police officer shall forthwith give the information regarding such arrest and the place where the arrested person is being held to the designated police officer in the district and to such officer of another district where the arrested person normally resides. So even the police officer of that district is also made aware that this was a person who was taken and kept in custody. Proclamation of arrest, the property to be attached, the provisions remained largely the same. Now, the only one important provision that is added in proclamation is earlier it was section 82, that if a person is absconding, then only in category of offences the proclamation was permitted to be used. That used to be largely the heinous offences or offences punishable with death, imprisonment for life. But now even for offences more than 10 years, the proclamation can be issued and he can be declared as a proclaimed offender, so that 82 the procedure is property can be attached. Now again, the search and seizure is expected to be carried out through audio, video, electronic means. So that when a search, somebody comes in the house, and you don't know, we always see in the movies, no, when we have a search warrant and they remove everything. I mean, everything is catched. So now this will give some sanctity to the whole process. So that what is being looked into, what is the manner and what is the manner in which the warrant is being executed, that can all be now audio video recorded. Now one very draconian provision, we will again have to face a lot of problem with this, is attachment, forfeiture or restoration of property. Now this is section 107. Now we are all aware of statutes dealing with money, like PMLA is there, MPID is there. Now you have 3-tier mechanism in all these statutes. Initially there will be a provisional attachment, objections are invited, then the objections will be decided, the court would be passing an final order, and there are appellate authorities or the tribunal who will confirm that order. Now this is a provision, we'll have to ultimately see how it's going to be interpreted or what was the object in introducing this provision. Now here the power is given to the police officer. It says that where a police officer is making an investigation and has reason to believe that any property. Now earlier the Supreme Court interpreted that this any property, as far as seizure was concerned, it will not be immovable property, it will be only movable property, and as far as immovable property is concerned, you can only have possession of those documents, title documents or something. But now the wording used is intentionally any property which is derived or obtained directly or indirectly as a result of criminal activity or for a commission of offence. He may, with the approval of Superintendent of Police or Commissioner of Police, make an application to the court or the magistrate to take cognizance of the offence and for attachment of such property. Now the whole difficulty here is, now of course the magistrate, when it comes before the magistrate, when the IO makes an application, he'll issue notice to the accused. But what is the mode by which, because accused is not the only person involved, they may be at times, like in PMLA or in MPID, we see there are so many third parties who come before the court and they said, no, this is not my property, I have nothing to do with this. It was in fact the father comes and says, this is my property, the son is showing it in his name, it is not in his name. Now where does a person get an opportunity, because notice it's be issued only to the accused, subsection 2. Now this will have to be really looked upon, we don't know how it will be construed, but definitely there is no mechanism as we have in PMLA or special statutes, a 3-tier mechanism. Objections not invited, only the accused and the court, and the question is this, what is the mode by which the magistrate will come to know what are the title documents or authenticity of the documents? A magistrate is not going to send somebody to see on the property. So what comes before him by the police or what is brought before him by the accused? There may be other persons who have third parties who are involved here. They are completely kept out of it. So this is a section which we don't know how it is going to be applied or implemented, because the magistrate has very restrictive power, and it only says that the magistrate shall, on the basis of the material brought before him. So he can't go beyond it, whatever is produced before him, no objections to be invited. So this provision may pose a little difficulty. Now we'll come to the most important of the provision. Now this is as far as registration of FIR is concerned. Now earlier the procedure used to start from 154. Now it starts with 173. FIR, registration FIR, because the whole machinery, investigating machinery set rolling when the FIR was filed under section 154. Now you have this provision in form of section 173. Now this is a very peculiar provision. Now what is added is the information could be given orally or by electronic communication also. Fine, as long as this is okay. But when it is given by electronic communication, the person who gave the information should come within 3 days to get it affirmed. Otherwise the FIR is not going to be registered. Now see the problem. Now there are bystanders, somebody has seen a murder. He's seen that somebody stabbed him. He don't want to disclose. It happens that he don't want to disclose. He just dial and says that such and such thing had happened. A murder has taken place. Now what do? Do the police officer not go on the site because this was received telephonically? The FIR shall not be registered till he comes after 3 days, because this says that subsection 2 of this 173 says by electronic, if it is by electronic communication, then it shall be taken on record by him on being signed within 3 days by the person giving it, and the substance shall be then entered into so and so, and then the investigation machinery will set more rolling. Now this is, we don't know how it's going to operate. It's good for some cases that somebody makes a frivolous complaint on phone. Some lady makes a complaint and she never comes to a firm. Good, the police will just ignore it. But what about a bystander or a person who really don't want to get involved into it, but he has seen an offense taking place? So whether the police will reach the spot or not. Because earlier it was receipt of any information, and rather now here it is, the wording you start with every information. Earlier it was any information. Now this we'll have to see how does it operate. Now as regards police diary, the offences making technique, now we all know there was little difference between an FIR and the private complaint. Now to have that, most of you must be aware of Priyanka Srivastav. Now Priyanka Srivastav, what used to happen was, if the police don't register the FIR, a person goes to the police station, file a private complaint, 156(3). Now a magistrate can take cognizance of this complaint under section 190. Now in such cases what happens is this, frivolously or without going to the police station for some petty reason, something by way of vengeance, police says that no, I am not going to register this FIR, this is of civil nature, or some period has lapsed. He goes and files 156(3). Magistrate issues order, take cognizance. Now to scuttle this type of cases, Priyanka Srivastav, the Supreme Court had issued certain guidelines saying that he should file an affidavit before the magistrate that I had gone before the police, they had refused, and this is the cause, this is truthfulness and verification, there is some truth in it, otherwise he will be responsible. Now this is included in this by providing that upon receiving a complaint, he shall be on verifying, this will be taken into cognizance only after this compliance. So Priyanka Srivastav is in a sense included in this provision. Another safeguard which was against a public servant, because that was only in the Maharashtra amendment we had introduced it under 156(3), by providing that if it is a complaint is against public servant, then sanction was required. This was only a Maharashtra amendment, but now it comes in the code itself, that any magistrate empowered under section 210 upon receiving a complaint against a public servant arising in the course of the discharge of his official duties, not a complaint of his own, some dispute, order an investigation subject to receiving a report containing facts and circumstances of the incident from the officer superior to him, and after consideration of the assertion made by the public servant as to the situation that led to the incident so alleged. So it will be not automatically, some superior or the report would be called for, and then only an offence can be registered against him. Now as far as submissions of report, final report under 173, the provisions remain the same. Power of the police officer to require attendance of witnesses, except those who are above 60 years, they will be exempted. A person suffering from acute illness, he will not be compelled to attend the report to the police station. 161 now becomes 181. 182, it's the same way, to what extent, and confessions also remain the same, except that as far as women are concerned, the confession should be probably recorded by a woman magistrate. This is the only change. Then, now most controversial is going to be section 187, because 167 earlier was a provision when the investigation could not be completed within the earlier, because the procedure is this: as soon as a person is arrested, within 24 hours he is required to be produced before the magistrate. The magistrate will grant either in judicial police custody or magisterial custody. Now the law that was evolved, it's not, remember in criminal law, there is no timeline for completion of investigation. But if the investigation is not completed within 60 or 90 days, depending upon the type of offences, the benefit accrues to the accused. And what is the benefit? He is entitled to be set free on default, what we call as a default bail, if that is considered to be an indefeasible right. Now, right from Sanjay Dutt, Hiten Thakur and Anupam Kulkarni, the position of law then was, though because of the proviso that was appended to section 167, it boiled down ultimately that the police can have custody for the initial 15 days. And thereafter, it will be necessarily magisterial custody. A recent decision in case of Senthil Balaji, when the minister was arrested, the Supreme Court, it came before the Supreme Court, the facts were very peculiar, that I think for 14 or almost 15 days, he was in the hospital. So police was not able to avail any custody. Now 15 days, obviously he comes on the magisterial custody, he'll apply for bail. Now, therefore, the Supreme Court expressed that we need to reconsider Anupam Kulkarni. Now, we don't know whether it's prompted because of that or the other aspect we tried to find out. I mean, when you look at the debates and all, not much of the debates, but if you look into what transpired, what was looked into, the idea was this, that sometimes what happens that some material comes before the police after 15 days. Now, like for example, some co-accused is arrested, and then along with the co-accused, you have to confront him with some material. But then you don't have the power to have, because he is already into magisterial custody. When he is in magisterial custody, it's not like that he cannot be taken for investigation. But it makes a difference. When he is in a police custody, we all know what impact it has. What is the insistence of police custody? Because they say that we can really put the accused to test and see to it, confront it for all the material. Now, this angle was looked at from at some other point of time. If after 15 days some material is available, then what to do? Now, therefore, this section, it says, now this is a very peculiar section. We this will have many facets to be argued. Now, it says that the magistrate to whom an accused is forwarded in this section, irrespective of whether he has or has not jurisdiction to try, this is not relevant, after taking into consideration whether such person has not been released on bail or his bail has been cancelled, authorize from time to time the detention of the accused person in such custody as such magistrate think fit for a term not exceeding 15 days in the whole. Now here there is addition, or in parts, at any time during the first 40 days or 60 days out of 60 or 90 days. Now this difference in parts, now the question that will have to be, which would be of course put forth is, now when he comes in judicial custody, he applies for bail, he is released on bail. Now what happens when you want a police custody after this, whether he will have to be taken into custody once again, because he is now in police custody. So whether the bail will have to be recalled, or you can say that the bail is the order of bail is kept in suspension, then for how many days? I mean, if first it was only 2 days, then remaining 13 days he will be out. This is, we don't know how, probably Mr. Badeka will argue it someday. So this is something, because you see the wording of this section, whether such person has not been released on bail or his bail has been cancelled. This is also added in the section. And the proviso which was there earlier, so 167(2) proviso, that's completely eliminated. So this we'll have to look at from how, but it is going to make a difference, because this is going to, all those earlier decisions, they all said earlier 15 days. If this is the intention, is to have the custody, police custody, even at a later part when some material comes, but then the question is what happens, because once he came in judicial custody, he applied for bail, he was released on bail. So how do you tackle with this situation? So this is a provision which would require a lot of brainstorming, and we all know it will take years together probably, because first it will be the magistrate who will be struggling with this, then it will come to the High Court, and by the time it goes to the Supreme Court, one doesn't know what's going to happen. Now, so these are some things which you will find that this is a significant provision where it will have to be really pronounced upon, depending upon how it is tasted. Now, another provisions as to inquiry, you will find that when a private person takes custody of a person, because it's also permissible, a private person can also arrest a person, no? But he shall be produced, his only timeline is 6 hours now, that is reduced. Now powers to summon, so largely if you will find, there are no changes as far as the procedural aspects is concerned, powers of the courts is concerned, the procedure to be followed by the trial courts. Now one significant aspect as regards that earlier 200 and now 223, when the magistrate takes cognizance on a private complaint. Now 223 says, no cognizance shall be taken by a magistrate without giving the accused an opportunity of heard. Now the law till this time was this, at this time the accused has no right to be heard, because he is, while taking cognizance is taken of an offence, not of the accused, and when the magistrate has taken cognizance of the offence, the accused need not be heard. But now there is a proviso which says that accused shall be heard at this stage also. Now that will be again debatable, because if he comes at that stage, because all the while the law was this at this stage, similarly at the stage of discharge, when he goes at the stage of discharge, the law let down all the while, and what we have followed is that accused has no right to produce any material. It will be only the material produced by the prosecution before the judge which should be looked into. Accused will not rely on any material. So going plainly by the material produced, the judge may form an opinion whether he will go for framing a charge or whether he will discharge. Now we don't know how it would be construed here, because at the time of taking cognizance also the accused has to be heard. So a lot of time will also be, but maybe that it is with this angle that that threshold itself, it will come to an end. But it may consume time also. Discharge provisions largely remains the same. So these are largely the you can say salient changes. Apart from this, you will find identification of a person now under section 54. Identification of a person arrested can be through audio video recording also. That's one provision, advancement of technology. Now search seizure, as I have already told, 107. Now, another important feature is a new feature is the assistance of forensic experts on the scene. Now, we are not yet ready for that. So, the Criminal Procedure Code says that after 5 years or within 5 years, the state government may take steps, because it's only what we watch is either in Hindi movies that you go and collect it from there, picking it up. But now they say that for every crime scene, the forensic expert shall be visiting the scene itself. But of course, when we are facing a situation that when the samples are sent for forensic analysis in the laboratory, the trial gets over, the charge gets framed, but the samples do not come, and by the time they come, we have inconclusive reports. Time and again, PILs have been filed. The reason that is analyzed is this, that we have short of people, the samples keep on lying, sometimes they get mixed, we really don't know, the results are inconclusive. But anyway, 5 years time is given to the state government. But one thing is sure, we are at least on a progressive mode. Now, the legislature was quite conscious that it can't be done all of a sudden. So they said 5 years time, it is also permissible that if you don't have the machinery here, you can take the assistance from the machinery from other state, so that some or the other way, it's not a composite this thing. Recording of confession, this also can be through audio video measures, and it can be produced before the court. Then victim centric, I have already told to you. So these are some of the salient features. As far as the timelines which are prescribed, now delay in sanction, we all know 197, when a matter goes to sanction, for charge sheet is filed, cognizance, then there are judgments, whether the charge sheet filed without taking cognizance, without giving sanction is valid or not valid. Now this problem is nipped in the bud by providing that under section 280, decision shall be taken on sanction within 120 days of the receipt of request, failing which sanction shall be deemed to have been granted. So this is very important feature. Then Another important is section 283 for summary trial, which is made mandatory for petty and less serious offences like theft and all. Now, in cases of punishment, the magistrate may, now this is magistrate can try up to 3 years. So, instead of 2 years, so large many cases of this petty thing would be covered because he is now empowered to take up cases which call for imprisonment up to 3 years. Now, witness protection scheme is little more strengthened. Now, as far as the bail provisions are concerned, now 436A, which was recently introduced and interpreted that 1/2 of the sentence, now it is reduced and it says that 1/3 of the sentence. So, this is one important provision, that is section 479. Judgment to be delivered in 30 days, that we don't know, that's not applicable to high courts, only applicable to trial courts. Then if trial is not completed, which was earlier also provision, not completed in 60 days from the date of recording of evidence, then 480 subsection 6 permits you to apply for bail. So these are largely the provisions of CRPC. You will see that there is not much change, but whatever are the provisions, in my view, they are with a view to take the procedure in an expeditious manner. Of course, some creases will have to be ironed because the facility, the machinery, but definitely if you look at each of the provision with an object of reducing the delay, or like for example, even if at the stage of cognizance, if he is to be heard, accused at that time, probably the other things may be avoided. But it will depend upon, it should not be in any way construed to mean that is going to result in delay of the trial. Because if at this stage the matter gets stuck, then you know what happens. At the stage of 200, as we see, 200 when it goes as a private complaint, now that verification, then sometimes he bring witnesses also because it's permissible from him. Then it goes like a mini trial. So we'll have to see how it really comes out. Now, as far as Evidence Act is concerned, there are no more changes except what type of evidence which we are going to look for. Apart from this primary evidence, secondary, the principles of evidence undoubtedly remain the same. There is no change. Only thing is this, when we are looking at with this angle of this electronic evidence, what would constitute primary evidence, what would constitute secondary evidence, they are only included and excluded. Nothing else has changed as far as this is concerned. So we have now seen the major changes of this BNSS is one aspect I've missed out, was registration of a zero FIR. I mean, it was being done now. It was not that this was procedurally being done, but now it is introduced in section 173(1) of the BNSS itself. It says that FIR can be registered regardless of the location where the offence was committed, then it gets transferred in due course to the Reckul police station. Now, there is also a provision in 173(3) itself, that is for conduct of preliminary inquiry. Now, we know the Constitution bench judgment in Lalita Kumari. It said that it's not, except those categories which are provided, preliminary inquiry, once any officer comes to know of a cognizable offence, he'll immediately register the FIR. Now, there is a specifically, section 173(3) says, for offences punishable with imprisonment between 3 to 7 years, the officer in charge of a police station may conduct a preliminary inquiry with the permission of the Deputy Superintendent of Police to determine whether there is a prima facie case, but the preliminary inquiry shall be concluded within 14 days. Now, the question is this, whether the FIR will get registered or not. If the preliminary, now if it's not, it's up to 7 years, 3 to 7 years. Now, if an offence, if a person goes, then the FIR don't get registered. Only after preliminary inquiry, the FIR will get registered. This is again, whether after taking cognizance or whether after filing of FIR or without preliminary inquiry, otherwise he'll go and complaining, he says that no. And one thing which I found lacking was, what do we do? if he comes to a conclusion that no offence is made out, then what does he do? Is it permissible for him to refuse registration of an FIR? Because cognizable offence is already indicated. Whether it lies or not, so what's the purpose of this preliminary, whether a prima facie case exists? If he finds no, then whether he can refuse registration of FIR. So this will have to be again tested. Then forwarding of daily reports to magistrate once in 40 days, this is procedurally to have some control of the magistrates over the police stations. So these are the largely the handcuffing I have pointed out to you, medical evidence, remand procedure we have seen, 167 now, confessions, completion timeline is once again in section 193, like related to specific sexual offences and the protection POCSO must be completed within 2 months from the date of information was received by the officer in charge. Now this also applies to section 64, some of the sections of the Bharatiya Nyaya Sanhita. Copy, as soon as the charge sheet is filed, the copy, electronic copy will be transmitted to the accused. We don't know how, now, but now everybody has a mobile, so probably it will be easier. But so the whole purpose is this, that as soon as the charge sheet is filed, it's communicated and the record is made. So these are some of the trial in absentia of proclaimed offender, because earlier the provision was this, the procedure to be followed was 299. So if the accused is not available, then what they used to do, they used to record the evidence by recording it under 299, but it could be used after the accused, after the accused was absconding is found, it could be used only in the given circumstances. That is when either the officer was dead, not to be found, absconding, or whoever the witness was. But now it says that the trial can go on. You don't have to wait because otherwise what they used to do, they used to segregate the trial, absconding accused, proceed with this trial by keeping an option of 299 open. But now it says trial in absentia of proclaimed offender under 356, it can go on. Charge has to be framed within 60 days from the date of first hearing. Now we get so many bail applications, charge not framed for 3 years, 4 years. So 60 days from the date of first hearing. Now the whole problem is this, if this has to be followed, these guidelines, then what happens to the old cases? We'll have to really find out. So I think since I have already told you that as far as the Evidence Act is concerned, you just read it plainly, because there is no change in the Evidence Act at all. The provisions remain the same. Only thing you have to read it now with the electronic evidence. That's the only change. Thank you very much.
Thank you, Justice Dangre, for this very informative talk. This concludes our lecture for today. Thank you very much for attending. We have tea and snacks organized outside. Even for those sitting in the library next door, please come, have a cup of tea, have some snacks, and you all can then go home or wherever else that you all would like. Thank you very much. Until the next lecture.